Okay, our next case is Bell versus State of Florida and Bell versus Secretary Department of Corrections, numbers 2024-1264 and 2024-1556. Whenever you're ready.
Thank you. Good morning, and may it please the court. My name is Adrienne Shepard, and I and my co-counsel Ali Shakur represent Jesse Bell. Mr. Bell is the appellant in this case. We are here on appeal from the Circuit Court's summary denial of Mr. Bell's initial motion for post-conviction relief filed pursuant to Florida Rule of Criminal Procedure 3.851. I intend to focus my argument on Mr. Bell's involuntary waiver of the right to counsel. As an initial point, I should state that it does appear that Mr. Bell's case is one of factual first impression before this court, and that a capital defendant is asserting that his waiver of his penalty phase counsel was rendered involuntary by abuse and mistreatment that he suffered whilst in prison while awaiting trial. With that being acknowledged, the fact that I do think this is a case of factual first impression, Mr. Bell's request for a remedy for this constitutional violation is based on legal principles that are not new.
Before we get there, can we talk about whether you think the Feretta colloquy or any of the other colloquies that your client had with the court were incomplete or mistaken as a matter of law? Can we put aside at the outset that the court did what it had to do in terms of colloquying your client?
Yes, Your Honor.
So once we've established that the court did the right thing, the question then becomes, why didn't your client, your client was demonstrably capable of filing things with the court and raising arguments because he did. So the question then becomes, why didn't he avail himself of those avenues and raise the issues you're raising now by saying, hold up, the Feretta colloquy failed to catch the fact that I'm being abused, and that was involuntary? Why should we look past that silence in the record?
Well, to respond to your question, Justice Curiel, I can make 2 points. So number one, Mr. Bell was being severely abused and mistreated by correctional officers at Florida State Prison. They were transporting him to the courtroom. They were in the courtroom. He was afraid of retaliation. He didn't know that if he stood up and... Yes,
well, I hear you saying that, but I think he's still in the Florida State Prison, right?
No, sir. He's at Union Correctional Institution.
Okay, well, he's in the Florida correction system. So if he was afraid to blow the whistle then, but he's happy to blow the whistle now. I don't quite get that, because he's basically subject to the same authority and subject to the same sort of situation he was in before. So it just doesn't quite add up that that he's blowing the whistle now, but but for some reason was unable or unwilling to before.
He is not in the same situation, Justice Kennedy. He escaped from the abuse that was happening from the Florida State Prison guards. It was well known to the inmate population at Florida State Prison that particular population of correctional officers abused inmates who had a charge for attacking a correctional officer. Once Mr. Bell made it to what he saw as the immediate safety of Union Correctional Institution, he's no longer being abused. He's now safe. He can now talk about this. I would like to go back to my second point to your question, Justice Curiel. So Mr. Bell was afraid. The Florida State Prison correctional officers were in the room. Also, anytime he filed something as a pro se defendant, he has to hand that piece of paper to the correctional officers. He can't trust that they're not going to read it.
I guess the trouble with that argument is if he felt this pressure so acutely, why waive counsel? Why not just have your court-appointed lawyer blow the whistle and take other measures to safeguard you?
Yes, Your Honor. It speaks to how involuntary this choice was and the fact that it was not made in the absence of subverting factors. It was not clearly free and responsible. He sat at Florida State Prison for 6 months without the appointment of counsel, without a first appearance. He had no one to speak for him. After 6 months of being abused and denied food and the threat of abuse, I think it affected his mental state to the point...
I think if you're right, then we can never trust a Feretta colloquy. You're sort of proposing to us an unfalsifiable hypothesis that we can never trust that someone won't be in this sort of secret position. And that's why I started with whether you thought the Feretta colloquy was adequate. Because if you are making the argument you're making, then I think what you need to argue is that courts should always, or at least in circumstances like this, be concerned about voluntariness and, I don't know, colloquy the defendant in a closed court or something. Are you making that argument? Are you
No,
making?
Your Honor.
Okay, so then help me out. I don't understand, because it sounds to me like in a case where someone is alleged to have attempted the murder of a guard, what you're really saying is we should always just assume that this person is being exposed to risk, and therefore Feretta is inadequate, and we need to rethink how that person is colloquied about voluntariness.
I'll state first, to your point about trusting Feretta inquiries, we can, at a basic level, trust them when they're done correctly, and Judge Fina did the Feretta inquiry correctly. What we can't trust is Mr. Bell's inquiry, not because the trial court did anything wrong, but because of what we've discovered in post-conviction. I will state that because the lower court denied an evidentiary hearing, this court must accept the factual allegations in our briefing as true to this extent. And so there is corroboration of this abuse. As far as the court having to ask about abuse, not every single time, it's the case that Mr. Bell was incarcerated at Florida State Prison, where it's well known that guards would abuse inmates who had a charge for attacking a correctional officer.
I guess that takes me to my next point, which is, or question, which is help me understand, if any, the causal relationship between the abuse and the voluntariness of his plea.
Yes, Your Honor. To answer that, I would first state as a prerequisite matter that we really need an evidentiary hearing.
Well, is there allegations, though? I mean, you would agree that as a legal matter, in the context of an unintentional waiver, the causation element is legally significant.
It is.
What allegations do you think were raised to establish that causal connection, just as a factual allegation?
Yes, Your Honor. What we've argued in our briefing, and what Mr. Bell would testify to if he could at an evidentiary hearing, is that after being abused for so long, he couldn't see any other way out. It was about, how do I reach a place of immediate safety? How do I get away from Florida State Prison
So that would
today?
be causal to his state of mind, but isn't, from a legally significant standpoint on causation, it's that the abuse was... he was abused in order to procure a waiver, essentially. There needs to be that link.
Go ahead. My answer to that would be no, and I would point this court to the Figueroa-Sanabria v. State opinion. Now, that is a little bit different.
No. Figueroa-Sanabria is completely different. In Figueroa-Sanabria, the court put a false choice before the defendant. The court was mistaken in conditioning a waiver on a selection about counsel, and you have forsworn any trouble with what the judge said in the Feretta colloquy. Figueroa-Sanabria, respectfully, is of no help to you, unless you think I'm wrong about it.
I do respectfully disagree, and I was, to Justice Sasso's question, she was asking whether or not we had to prove, correct me if I'm wrong, that we had to allege that the abuse was for the purpose of causing the waiver. Is that correct?
Yes.
Okay. So in Figueroa-Sanabria, the trial court, and perhaps I misread the opinion.
Or perhaps I miswrote it.
And I know you authored the opinion. There's no discussion in that opinion of Figueroa having to prove that the trial court misadvised him for the purpose of eliciting that waiver. The trial court definitely misadvised Figueroa about the nature of his right to counsel. And you're correct. In Mr. Bell's case, this is factually different. But what we're requesting is that this court take those foundational legal principles that Your Honor authored, that the waiver of counsel must be made in the absence of subverting factors so that the choice is clearly free and responsible. And I know that this court found in Figueroa-Sanabria that Mr. Figueroa could not make a voluntary choice because he was forced into that constitutionally offensive decision based on trial court's misadvice. We are requesting that this court, or based on trial court's misadvice, we are requesting that this court take those foundational legal principles that are important and apply them to the facts of Mr. Bell's case. And so I would state that, in response to your question, there's nothing in the Figueroa opinion that implies that Mr. Bell must prove that the abuse was for the purpose of eliciting the waiver.
But you've conceded this is a factually new claim, novel. And I guess I'm struggling with, if we take your factual allegations as true, why would this not be closer to some competency issue rather than a waiver issue? It doesn't, to me, it doesn't fit into a coerced waiver. when you're basically saying these conditions in his life created so much stress that he was in a mental state that he could not make an appropriate decision. That to me is completely different from what we typically see in the coerced waivers.
So my understanding of the competency, and we're not alleging anything related to his competency,
Right.
is that you have to have a rational understanding of the proceedings and be able to rationally consult with your attorney. It's obvious, we acknowledge, Mr. Bell is smart. He had a rational understanding of the proceedings. He knew, if I waive counsel, I can get out of here. If I waive counsel, I can speed this process up. So the voluntariness comes from the fact that he didn't want to make that choice. He was forced into this constitutionally offensive choice from sitting at Florida State Prison for 6 months with no help, being abused, being denied food, and it got to the point where he said, I can't take this anymore. He understood what he was doing. He didn't want to do it. And I think under this court's dictates in Figueroa Sanabria, that can't be a voluntary choice, because it's clearly not responsible to try to reach a place of immediate safety by inviting a death sentence. But he was so tired, so desperate that he couldn't rationalize. I think he constructively understood it, but he couldn't rationalize that I'm reaching a place of immediate safety. The guards aren't abusing me anymore, but now I face prolonged unsafety. Now I face a death sentence. It's simply not a voluntary choice. But we are not raising anything related to Mr. Bell's competency. And
well, help me understand again. I apologize if I've gotten the sequence of things out of order here, but when he had counsel, did he ever complain to counsel about the abuse?
so we don't know, and that's why we need an evidentiary hearing. We requested an evidentiary
But you
hearing.
made an allegation of that.
An allegation of what?
Well, I mean, do you know? I'm just struggling to understand how there was not an opportunity to get this blow the whistle, as I indicated before.
As to trial,
because there's counsel. Well, let me just ask about the sequence of events. Do we know that the abuse was taking place based on what your claim is at a time when he still had counsel?
I do believe so, but I would say that the best way to answer that is to have an evidentiary hearing.
Well, we can always have an evidentiary hearing, but you've got to make allegations, and we've got to have some basis for that.
Right. Well, and the basis for the evidentiary hearing is Rule 3.851 subsection F, and that states that the trial court shall, not may, shall schedule an evidentiary hearing on claims asserted by the defendant as requiring a factual determination. We have several things that required a factual determination beyond what we were able to brief. Number one, what did trial counsel know about the abuse? Did trial counsel know it all? What could trial counsel do in a week? Why didn't the trial counsel tell the trial court? We don't know what we don't know. Number two, the other factual determination that was needed.
Well, but you're, again, it seems to me that part of your claim would be that he told counsel about it and the counsel didn't do anything. And that's why he was in this jammed up situation. He's going to know what he told counsel. You don't have to have a hearing about that. It seems like to me that would be part of your allegations to show that he was in this vice of abuse with no way to do anything about it other than to waive counsel and be off to death row. And I'm just.
So I respectfully disagree on the need for an evidentiary hearing, because even if Mr. Bell says, I told trial counsel every single time I spoke to him, we need trial counsel's side of the story. And I'm not saying that Mr. Bell's making anything up, but we need trial counsel to tell us what he knew.
Well, that might be it, but if you made the allegations and pointed us to that aspect of it, but without having made those, I'm struggling to see how this is other than something that's just kind of made up.
So you can see, though, that in the motion you're not alleging that that your client told trial counsel anything.
We are not alleging that because
Okay.
we need trial counsel to tell us on the record.
Well, no, but I mean I understand but it seems like your motion would have to sort of put that issue in play, and then you may need an evidentiary hearing to sort of flesh out, whether it's true and what consequences it had. So as far as just in terms of sort of just the kind of the doctrine here, I mean, so one way to get this in front of us in this context is through ineffective assistance of counsel, right? Which would involve you having had to allege, that counsel knew. I mean, I'm suggesting this, that you would have had to allege that counsel knew something about this and failed to do enough about it to meet their professional obligations within the amount of time they had and everything. So that's kind of one sort of state, to the extent that the appointed counsel sort of is carrying out the state's obligation. That's that. So if the kind of state wrongdoing here is the correctional officers themselves, then what's the claim then? What's the, you know what I'm saying? How do you fit this into a post-conviction context?
I do want to respond to your Honor's question about making the allegation of something trial counsel knew. So we do make an allegation, an argument to that
in the motion?
In our briefing, in the initial briefing.
Doesn't, you have to, I mean,
yes,
the
in the motion, yes.
They counter in the motion.
Yes, if you look at the Rule 3.851 motion, in Claim 2, it discusses, particularly in subsection A, how trial counsel received a discovery exhibit from the state that listed an audio-taped interview that Mr. Bell had with a state attorney's office investigator in October of 2019.
That's the one where he says, I was roughed up.
Yes.
And then they both laugh.
Yes.
Uh-huh.
And he may be laughing because he's scared. He's trying to put on a show. Also, we don't always know why people respond the way that they do to trauma. People's brains are different. But to your point, Justice Muniz, trial counsel did at least receive that discovery exhibit. What we don't know did trial counsel have enough time to listen to the interview? So there is some evidence indicating that trial counsel could have known, because he did receive that discovery exhibit. He was copied on it. We need trial counsel to tell us, did you listen to the interview?
I mean, so the allegations, though, sort of drive what then you would need a hearing for. But let's put the counsel's conduct to the side, and then could you just explain, because I mean, this is an unusual, obviously, as you started off acknowledging, this is an unusual sort of claim to be raising in post-conviction. And so just help us understand sort of, if we're just sort of trying to fit it into the available categories for post-conviction, how we would even get to this in this context.
I think and I know you're asking me to put aside trial counsel, the most obvious available avenue is trial counsel, but to try to provide another avenue of relief to answer that question, what we have is a circumstance, because this court has held on direct appeal, speaking about direct appeal for a moment, that the involuntary waiver of counsel that results in a complete deprivation of the right to counsel is fundamental error that does not require a contemporaneous objection at trial. Okay. Now, I recognize...
So that cuts against you, though, in the sense that that means that you could have raised it on appeal.
So, Mr. Bell could not have raised it because the abuse was not apparent on the face of the appellate record. So what we've requested in our briefing is that this court recognize in these very narrow, very specific circumstances...
But hold on, you're saying the ineffective assistance of counsel wasn't apparent on the face of the record, right?
No, Your Honor, the abuse.
But the involuntariness, they could have raised some sort of, I don't know what the government actor who committed fundamental error would be, but I guess the point is, if they could have been raised as fundamental error, then we know that ineffective assistance of counsel cannot be raised,
of course,
on appeal, right? We know that if anything that could have been raised on appeal can't be brought in post-conviction, right? So by telling me that by then bringing me back to sort of direct appeal type stuff, you're defeating your argument, Your Honor, for why we can take it up now.
I recognize the precedent that claims that could have or should have been raised on direct appeal are not cognizable in post-conviction.
Okay.
What we're asserting is that that the fundamental error, putting trial counsel aside, the fundamental error could not be raised on direct appeal because evidence of the abuse was not apparent on the face of the appellate record. There's nowhere, because Mr. Bell was so afraid to speak about what was happening, there's nowhere that direct appeal counsel could look at the record and say, oh, he waived because he's being abused. So we have this severe constitutional violation, this manifest injustice.
Is there any precedent for, outside of the ineffective assistance context, is there any precedent in post-conviction for essentially wanting sort of a do-over on voluntariness. I mean, it sounds like that's what you're essentially asking for.
What we're,
right?
I can't speak to any precedent, Your Honor.
Oh, so you don't know of precedent for that?
Not as I stand here now. And what we're requesting, not that this court overhaul. I see that I'm almost out of time. I've got about 30.
No, we'll give you more time.
Is that okay? Thank you.
No, because you're talking about,
Yeah.
you started off by saying that you want us to sort of apply these first principles, right? And it seems like we've got the first principles on ineffective assistance. We've
Right.
got all the first principles about trying to do things during the direct appeal, which seem to cut against you. So I'm just trying to understand, because we have to fit it into a category that
Correct.
works for post-conviction.
I think.
So what, other than ineffective assistance of counsel, which I think would depend on your allegations, which perhaps weren't there, but we'll look at it. But then if that box is not available, then what is available to you?
I don't believe there is another box available. And so what Mr. Bell's case represents is we do have a manifest injustice. We do have an extreme constitutional violation. But I think it just procedurally, we don't quite have the perfect box. We're trying to put a round peg in a square hole. And that's why we're requesting that this court recognize that very narrow exception, specifically just on the waiver of counsel, where a fundamental error has occurred, but it couldn't be raised on direct appeal. We're requesting that this court recognize it in post-conviction just for fundamental error, just for the counsel waiver. And so we're kind of asking for this court to extend the fundamental error doctrine to post-conviction.
Well, I mean, yeah, okay. I mean, I don't blame you for asking, but I mean...
That's what we're asking for, Your Honor. I see that I've gone
okay,
over. Can I have 5 minutes?
You can have 3 minutes. And if you want to wrap up, you can take 30 seconds to wrap up, too.
I'll wait until rebuttal.
Okay,
Thank
thanks.
Mr. Chief Justice, may it please the court again. Jason Rodriguez on behalf of the state of Florida. Your Honor, as Mr. Bell did, I will also focus on the counsel issue, and I think really where we ended is a good place to start. And that's that when we're dealing with this issue, it is an issue that could in fact have been preserved and raised on direct appeal.
In fact, on direct, am I right that Bell raises as a mitigator the court engages with, and then we on direct appeal consider the following? He says, Bell says, in mitigation, hey, I've never abused any other guards at the Correctional Institute, right?
Yes.
Okay. I make of that fact that he was willing to discuss the subject of abuse, and indeed he said, hey, in my defense, this is the only guard I've tried to murder. Wouldn't that have been a pretty good time to raise the fact that he was being abused?
I would think that basically any time with counsel, we know he had conversations with counsel beforehand. He's appointed counsel, I think it's on December 5th. There's some conversations about him wanting to waive. There's consistent conversations after that up until the 13th where the court asks him, have you talked with counsel? And he says, yes, and I don't want counsel. So I think there's a number of opportunities where he can speak with counsel who is supposed to be the one who's his advocate, and then who can take whatever remedial measures need to be taken, whether that's, setting an ex parte hearing with the court if it's bad enough, doing it with just whatever needs to be done. Counsel's the vehicle to do that. The case that Mr. Bell cited was Farr versus State, where something similar was alleged to have occurred, and that's exactly what the inmate did. And Bell certainly, as this court, I think, analyzed in his competency or the competent substantial evidence on his plea and everything on direct appeal, he's not shy about telling the court what's going on. So I think very easily this is something that could have been preserved and raised on direct appeal, if only through the avenue of counsel. As it pertains to kind of where we ended, we're in an area where this court said this is an issue that's procedurally barred, or this type of an issue is procedurally barred, rather. It could have been raised and developed on direct appeal. In fact, to get to kind of the allegations they raised in their 3851 motion, they did not allege counsel knew. They alleged counsel should have investigated based on the J.T. Williams interview with Mr. Bell about the abuse, and should then have found the inmates Boatman and Womack. There was no allegation that counsel in fact knew. It was counsel failed to investigate the issue, in essence.
And so in order for us to be able to evaluate that, the amount of time is a relevant consideration, right? And so
Right.
what's the amount of time it's a pretty short amount of time. I can't remember exactly.
So I counted about 12 working hours from when the state files and gives the interview that should have prompted all this, according to Mr. Bell, until the waiver colloquy, roughly. It's about 2 days, I think, straight, but it's about 12 working hours. And under no circumstances is counsel going to be ineffective for failing to investigate the massive quantity of information that the state gave him, find that singular interview, and then go and interview and find 2 other individuals. So if there was an allegation that Mr. Bell told counsel he was being abused, or that counsel knew some other way, we'd be having a different conversation. But they have access, and part of the whole purpose of 3851 is they've got a year to investigate their claims, to ask counsel these questions, to ask Mr. Bell these questions, and then make good faith allegations. If there's a conflict, then they get to make the one that's most beneficial to them, and we have an evidentiary hearing. But that wasn't what was raised here. So this is a situation where we've got a procedurally barred issue that cannot be raised in post-conviction. And I would push back as well on the concept of manifest injustice in this sense. When we're dealing with just the waiver of counsel, that I don't think gets us to a manifest injustice in and of itself. Because he still would have had complete control of the mitigation that he presented. It doesn't get us this idea where there's no possibility that he would have received a death sentence. And when we're talking about manifest injustice, an incredibly high standard that this court has very rarely found. The only illustration that jumps to my head was a biased judge overrode a life sentence and sentenced a capital defendant to death. So it's a rare circumstance. I don't think that part's been fleshed out in the briefing, but I don't think this fits into that paradigm in this context. The court has no further questions. The state will rest in its brief and request the court affirm.
Thank you.
Your Honors, I'd like to address 2 brief points and then conclude. So number 1, about ineffective assistance of counsel and what we need to allege. It is cognizable if we allege that counsel had leads on an investigation and failed to pursue them further. That can be ineffective assistance of counsel. You know you need to look into something. You don't look into it enough. You have to make a reasonable investigation. We don't have to specifically say that he absolutely knew about the abuse. We have to say that he should have known about the abuse. He failed to investigate it further. That's deficient. That is what happened here. He should have known. He had a discovery exhibit with that interview. He should have known. Now we need him to tell us why he didn't know or why he didn't investigate further.
Is that discovery exhibit the sole piece of evidence of what you now claim is the sustained systemic abuse of your client?
No, Your Honor. As far as the evidence of the abuse, we have the allegations in the briefing and the 2 affidavits from the inmates who were at FSP with Mr. Bell and knew the abuse was occurring. So I also want to speak to...
I mean in the record before counsel at that time.
Yes, I'm sorry.
That's it. So
from what we know.
Okay, so
Yes.
counsel would have had to find from that one statement that there was this crushing abuse going on that was rendering his decisions involuntary.
Not necessarily. That should have prompted counsel to speak to Mr. Bell. And I want to speak to the fact that as for the 12 working hours, we do not know that. That's nowhere apparent on the face of the appellate record. Trial counsel needs to tell us how many hours he had to work. That is asserting a fact into evidence that simply is not there. Trial counsel is the best person.
What does the record, just sort of the face of the record, show about the timing involved?
Sure. So the first appearance was on December 5th, 2019. The waiver was about a week later on December 13th, 2019. So yes, it's a short amount of time. But I submit that in a week, counsel could speak to his client. I see that I'm about 1 minute in, or 1 minute left, so I won't get to my second point. I'll simply conclude that we are requesting that this court remedy the extreme constitutional violation that was caused by Mr. Bell's involuntary waiver of the right to counsel. We've offered 2 avenues for relief that this court may take in the briefing. The first, of course, is to remand for an evidentiary hearing pursuant to Florida Rule of Criminal Procedure 3.851F, so that we can have a full and fair evidentiary hearing and get all the evidence on the record to answer your Honor's questions. In the alternative, under Figueroa Sanabria v. State, we are requesting that this court vacate Mr. Bell's death sentence and remand to the lower court for a new penalty phase where he can safely apprise himself of the right to counsel. And if your Honors have any further questions of me? Okay. Thank you. I appreciate
Thanks.
it.
You both sides did a great job with the interesting case.
Thank you.
All right.
Congrats.